Okay, well, welcome everyone for, and thank you for attending our home and community-based settings webinar. I know it's right at 11. We may have some few more people joining us, but I think we'll go ahead and get started. So just as a quick overview of what we'll be covering today, for some reason you have a hard time hearing us or anything throughout the webinar, please let us know in the comments box. But just as a quick overview of what we'll be covering today, we'll be talking about the purpose and the background for the new home and community-based settings rule. We'll be talking about the rule requirements themselves. And for those of you who have attended past presentations, we do have some new information. So there's some new guidance from the Centers for Medicare and Medicaid Services about the rule that we'll go over. We have some new ways for individuals to be involved in the rule implementation process. And we'll also be providing some examples of compliant and non-compliant settings just to give individuals an idea of what the practical application of the rule looks like. And just as a reminder, the state is the ultimate judge of compliance, but we just, based on our understanding of the rule, thought it may be helpful to give some practical examples. We'll also be holding a question and answer at the end. Feel free to type questions in the question box as the webinar goes on, and we'll hold those questions until about the last 10 minutes or so. And just by way of introduction, my name is Mary Ann Davies. I'm a staff attorney at the Disability Law Center, and I will be joined later in the presentation by my colleagues Laura Henry and Amberly Datillo. So just a little quick overview about the Disability Law Center. So the Disability Law Center is a private nonprofit organization, and we're designated by the governor as Utah's Protection Advocacy Agency. So all states are required to have a P&A, and in the comments to the final rule, CMS said that they expected and wanted P&As to be very involved in the rule implementation process, which is why we have tried to create a lot of educational materials, provide feedback to the state, and do webinars like this. So our mission as an agency is to enforce and strengthen the laws that protect the legal rights of Utahns with disabilities. We are a law center, and our work includes things such as accessibility, assistive technology, civil rights, community living, housing, education, Medicaid, Medicare appeals, employment discrimination. So if you or someone you know is facing any sort of discrimination based on their disability, we would encourage you to refer them to our offices. Our services are at no cost to clients. And so just before discussing the rule requirements, we want to give some background about the rule's purpose and goals. And the newish home and community-based settings rule does overlap with the state's obligations under Title II of the ADA. So Title II of the ADA of the Americans with Disability Act includes the integration mandate, and this requires public entities to provide services in the most integrated setting appropriate to the needs of qualified individuals with disabilities. In Olmstead v. LC, the Supreme Court affirmed Title II and held that unjustified segregation of individuals with disabilities is a form of discrimination prohibited by the ADA. And CMS, in the comments to the final rule, said that compliance with the HCBS Settings Rule gives public entities the opportunity to, in part, fulfill their responsibilities under the ADA and Olmstead. I also want everyone to keep in mind that under the ADA, the most integrated setting is one that is defined as a setting, or is one that enables individuals with disabilities to interact with non-disabled persons to the fullest extent possible. So when we're talking about integration and helping individuals access to the community, we're really talking about helping individuals with disabilities to interact with their non-disabled peers. So on January 10th, 2014, the Centers for Medicaid and Medicare Services, or CMS, announced a new rule to explain what kinds of services can be covered through a state's Medicaid-funded home and community-based services program. The new rule defines and describes the requirements for home and community-based settings and the person-centered planning process. It's important to keep in mind as we review the requirements for the rule that the rule seeks to define settings by the nature and quality of an individual's experience. And what that means is that these rule requirements are not a one-size-fits-all definition, but rather they should be tailored to an individual's needs, preferences, and strengths. So it will just look different depending on the individual and what supports they may need. So another thing that CMS is attempting to do with the settings rule is really draw a distinction between institutional and home and community-based services. So if somebody needs long-term services and supports, they can choose either institutional care or home and community-based care. Institutional services include things such as nursing facilities and intermediate care facilities for individuals with intellectual disabilities. And these services are part of the state Medicaid plan. So what that means is that if an individual meets the eligibility criteria, they must be provided with these services. Medicaid-funded home and community-based services are an alternative to institutional care, and these provide supports to individuals who need support to live in the community. And they are offered through waivers rather than through the state Medicaid plan. So that means that the state can cap the number of individuals receiving these services, which is why you hear so much about the waiver waiting lists. And then I also just want to be clear when we're talking about home and community-based services, these are waiver services. So this mainly includes services provided through DSPD, the Division of Services for People with Disabilities. So this includes things such as group homes, day programs, sheltered workshops, supported living, supported employment, but it also includes other waivers such as the New Choices waiver, which primarily helps people in assisted living, and then also the aging waiver. So when I think really a key takeaway is that because individuals must wait many years on waiver waiting lists, the services they receive truly should look home and community-based and support integration. Because if you want institutional care, you can get those services at any time, but home and community-based care you must wait many years for. So if you're a provider or an individual receiving services and you have programmatic questions, I think a good measure to ask is, does this look institutional? And we'll cover that more in depth later in the presentation. But just generally, institutions, some of the characteristics they have are, lack of privacy, regimented schedules, and less access to the community. So CMS has said that, the two really overarching purposes for the new settings rule is one, to improve the quality of the home and community-based service system, and two, to ensure consumers have full access to the benefits of community living. So under the new rule, in order for a service to be home and community-based, it needs to be in a setting that gives people real opportunities to work, live, and socialize in the community. So we want to talk about the rule requirements themselves. But before we go over that, I just want to make sure we're all on the same page that the state has until 2019 to implement the new settings rule. So right now the state's undergoing a process, which we'll cover later in the presentation, to measure compliance and help providers come into compliance with the new rule. But providers who were in existence before 2014 do have this 5-year rule implementation and compliance window. So under the new rule, to qualify as a home and community-based setting, the setting must be able to demonstrate the following 5 qualities, and we will go over those one by one. So the setting needs to be integrated in and support full access to the community. So I think the key word here is support access to the community. So by supporting individuals, it goes beyond just saying, hey, you can go into the community anytime you want to, but rather a setting and the staff that works there should look at an individual and ask themselves, what support does this individual need to access the community? And that may be as simple as just identifying community events, to getting help with transportation, to even providing, a direct care staff so that somebody can access a community event. And then the settings should also, with regard to integration, should also include opportunities to pursue competitive integrated employment. And community access needs to mirror the surrounding community. So what I mean by that is that if you're, living in an urban area, individuals not receiving waiver services, they may have greater access to transportation and community events than a rural area. And that's okay, so long as the setting provides the same degree of access that individuals not receiving services in the surrounding community have. And so the second quality is that the setting is selected by the individual from a range of options, including non-disability specific settings. So for example, when offering somebody a choice of residential services, you could offer them, group home, but also their own apartment. But these choices need to be real choices. So offering somebody an apartment they can't afford isn't a real choice. So that choice needs to be based on the person's situation. The third quality is that the setting needs to ensure an individual's rights of privacy, dignity, and respect. So this means that somebody should be able to close their bedroom door, have a private phone call, or have a secure place to store their personal items at work. The fourth quality is that a setting should optimize but not regiment individual initiative, autonomy, and independence in making life choices. And this really has to do with where and with whom people spend their time in terms of being able to decide, that they want to hang out with friends or, they want to go to the library. And a setting shouldn't force somebody to accept a highly regimented schedule if they don't want one. That doesn't mean that individuals don't have to have schedules. I mean, we certainly all have to go to work and keep appointments, that sort of thing. But just because somebody's in a setting doesn't mean their life should be any more regimented than anybody else. And then finally, just because somebody needs support to make these decisions isn't a reason to take that choice away. So for example, if somebody needs help to make and remember appointments, then a provider should help somebody to look at their calendar and decide, where in the week would be best for them to make an appointment. And then when the appointment comes around, the provider could support that individual by helping them to remember that they made the appointment and to get there, rather than just making that choice for the individual. And then the fifth quality is that a setting should facilitate individual choice regarding services and supports and who provides them. And this is mainly done through the person-centered planning process. And people should have a choice of multiple providers, have a choice of services. And generally, a provider cannot require someone to accept unnecessary services as a condition of receiving services in that setting. So for example, if somebody was really great at art and their day program, had a class where they taught some of the basics of, drawing and painting, that provider couldn't require an individual who's already really great at those skills to participate in that class as a requirement of being in the day program. So I think kind of the general takeaway from all these requirements is what these requirements are trying to get at is to ensure that individuals receiving home and community-based services, that their life doesn't look markedly different than anybody else's who's not receiving these services. So the requirements I just covered apply to all settings, including residential and non-residential, such as day programs and workshops. But there are also some additional requirements for provider-owned or controlled residential settings. And this would include group homes and assisted living facilities. So these additional requirements are that individuals need to have privacy in their bedrooms. Rooms should have lockable doors. People should have a choice of roommate. People should be able to decorate their own room. Individuals should be able to control their own schedules. And people should have visitors and food at any time. And then finally, the setting needs to be physically accessible to the individual. And with the exception of accessibility, all of these requirements can be modified, but the modification needs to be supported by a specific assessed need and justified in the person-centered service plan. And then also, if there's a modification, it needs to apply just to that person and not everybody living in the setting. So for example, if somebody has a dietary restriction, such as gluten intolerance, it would be perfectly appropriate to, make a restriction in their person-centered plan that, they supports them to not eat food with gluten in it. However, that doesn't mean everybody in the setting now has a gluten-free diet. That restriction would only apply to that individual. And so now we will move on to do some new CMS guidance, and my colleague Amberly Dattila will be covering this portion.
So since the settings rule was issued in 2014, CMS has also issued some additional guidance for stakeholders based on questions they've received, and we wanted to highlight some of that guidance and explain it to you. So the first guidance that was issued was regarding new providers in construction, and we feel it's important to address this guidance from CMS because it's been a particular area of concern nationwide, and we've included the guidance directly from CMS here in the slide. And so it says that any setting in which services were not being provided under an approved waiver as of March 17th, 2014, must be in compliance with the HCBS regulations by the effective date of the program. And so it was CMS's expectation that after they published the settings rule, that stakeholders wouldn't invest in the construction of settings or of licensing new settings that are presumed to have institutional qualities. And CMS also explained that the effective date is the time that the state submits a claim for reimbursement. And so what this means is that while providers who were licensed prior to March 17th, 2014, have the time of the transition up until 2019 to come into compliance with the new settings rule, providers that are newly licensed after 2014 and then newly constructed settings must already be in compliance. And so this is an important distinction between providers that were in existence prior to 2014 and providers that have been licensed since that time. The next guidance that was recently issued by CMS is regarding integration. And we've had a few questions about this from some providers. And so what CMS has said is that visits by community members have value, but do not substitute for community access for Medicaid beneficiaries receiving services in residential and adult day settings. And so what this means is that while it's great if a setting has an open door policy, and a setting should have an open door policy that allows the public to come in and interact with people that are receiving services in settings, the emphasis of the settings rule is to get people out into the community. And so it's not sufficient to bring the community into your setting. You must also be supporting individuals to integrate into the actual community. This next set of new guidance is regarding wandering. And I know that particularly on the aging side of things, providers have had a lot of questions about memory care. And what CMS has said in response is that provider-controlled settings with memory care units with controlled egress may comply with the rule if controlled egress is addressed as a modification and documented in the person-centered plan. And so CMS has said that memory care can be something that can be done for people in a setting, but as with other restrictions, there has to be a documented assessed need, and this has to be documented in the person-centered plan. And then also, this restriction has to be revisited in the future to see if individuals are still needing this type of support. If you look at this guidance, it's actually pretty long, and I think that it's pretty helpful. And so they talk about a lot of different environmental and programmatic changes that can be made to a setting in order to support a person that may have issues with wandering. And I think that this gets to the heart of the settings rule. The point of the settings rule is not to put a bunch of rights restrictions into people's person-centered plans, saying that, you know, they're just not able to access the community. What the point of the settings rule is to support people to make environmental and programmatic changes to allow them to make choices and to get out into the community. And so prior to trying to institute a rights restriction, providers should really be looking at an individual and seeing, you know, what supports need to be in place or what changes could be made to our program in order to make it so this person could be successful in the community and can make more choices for themselves. But again, I'd recommend that you read this. This is they had lots of good examples in it. Okay, and then the last set of new guidance that we've also had some questions about is that there are no grandfathered settings under the settings rule. And so the guidance has said that a state cannot choose to provide HCBS services in a non-compliant setting under a grandfathering approach. All settings must be in compliance by 2019. And so this is really the purpose of the transition plan. You know, we've known since 2014 that the regulation was issued, and we have until 2019 to bring the service system into compliance. And in fact, states are even required to put within that transition plan how they're going to relocate consumers who are located in non-compliant settings as of that 2019 date into compliant settings. And so it's really important to know that now is the time to make the changes that we need to come into compliance with this new rule. Okay, and so now we're going to talk about heightened scrutiny, and I'm just going to do a little introduction first of all. First of all, there are settings that are not considered an HCBS setting where we can't bill for waiver services. And these are institutions and include a nursing facility, an intermediate care facility for individuals with intellectual disabilities, or a hospital. But then there's a second category of settings, and these are settings that are presumed not to be HCBS. And there are three parts to these presumptively not HCBS settings. So first of all, if a setting is located in a building that also provides inpatient treatment, or if a setting is located on the grounds of or immediately adjacent to a public institution. And so here we're talking about settings that are either located in an institution or next to an institution. In some of our visits and our review of sites, we found a few of these, but we think that the majority of settings that are going to have some difficulty are going to fall into the third category. And so these will be more rare, but we'll talk about the third category in more depth. And so the third category is if the setting has the effect of isolating individuals from the broader community. So these three types of settings are going to be presumed not to be home and community-based settings. And so again, to refer to what Marianne said earlier, again, remember the point of the settings rule is that we really want community services to look community-based and not like institutions. And so we don't want to fund services that are in places that are either really close to or located within an institution or that actually programmatically look like an institution. And so we'll go into some more detail about what are settings that isolate. And so remember, first of all, before we go through these details, think about what an intermediate care facility or a nursing facility looks like. Here, people are going to have highly regimented schedules, probably less choice over how they spend their day, and then also they're going to have less opportunity to spend time in the community. And so that's what an institution looks like. And again, we're trying to make sure that our community services actually look community-based. And so here are the different parts that CMS has said are settings that isolate. So first of all, the setting is designed specifically for people with disabilities and often even for people with a certain type of disability. So this might be a setting that is specifically designed for for people with one type of disability, like a program for people with autism or a program that is solely for people with physical disabilities. Second, the individuals in the setting are primarily or exclusively people with disabilities, and on-site staff provide many services to them. Next, people in the setting have limited, if any, interaction with the broader community. And again, referring to that guidance, it's great and it's important that settings have an open door policy where the community is able to come in and visit the folks that are in those settings. But remember that this is not going to be sufficient according to CMS, and that individuals must be getting out into the community. And again, remember the standard is we're looking to see, we're looking to have people's lives be lived as closely as they would be as a person who's a peer who didn't have a disability. And then finally, the last factor is that multiple services are delivered on-site or co-located next to settings that are controlled by the same provider. And so this would be an example where you see either a day program or a sheltered workshop that is very closely located to a residential setting. People might have multiple services on site where medical providers are coming to them, or things like haircuts are happening on site, things that a person without a disability would go out into the community to access. And we are actually going to go into some more detail to give you some more concrete examples of what a setting that isolates might look like, but we just wanted to go over the different factors in this. Okay, and so once, so if a setting is deemed to be not to be HCBS, either it's adjacent to an institution, it's located within an institution, or it hits these factors of settings that isolate. Settings with these characteristics have to go through something called heightened scrutiny before they can be considered home and community-based services. And so what will happen is if you hit any of these factors, then a state is going to submit sufficient information to document that your setting doesn't have the qualities of an institution and does have the qualities of an HCBS setting. And again, remember, they're doing this because home and community-based services are an alternative to institutional care. Let's see, sorry about that. Okay, and so what's going to happen is the state is going to gather this information, and then CMS is going to review everything that's submitted to ensure that all participants in this setting are afforded the degree of community integration required by the regulation and desired by the individual. And one thing to note is that CMS has said that they are going to be looking for strong evidence that the setting is not institutional and that this is not going to be a low bar. And furthermore, it's really important to note that the setting in the state is going to have to demonstrate that all participants are afforded the degree of community integration required by the rule. Providing documentation that a percentage of the participants or some participants have community access won't be sufficient to show that the setting meets the regulation. And CMS has outlined some of the supporting documents that can be submitted for a person or for a setting to prove that it is not institutional or not isolating. And so you can submit zoning requirements to demonstrate that the setting supports access to the community. And so if you are zoned in an industrial area and you have little access to amenities like restaurants and stores and community activities, that's going to perhaps show that you're more isolating, but if your zoning can demonstrate otherwise, that would be helpful to submit. Next, you can show proximity to community settings and to public transportation. And so even if you're in an area perhaps that doesn't have public amenities, if you can show that you have access to public transportation that people using your setting can use, then that might be something that would help your case as well. Next, you can submit pictures of the site. And so we want to see how the site is set up, if the site is facilitating integration between the community and between the site. And also, trying to look at what's the distance between maybe if you own both a residential and a non-residential site, looking at, are they closely located, those types of things. Next, you can submit information about provider qualifications for staff that demonstrate that the staff is trained specifically for home and community-based support. And then next, public input on the setting in question. And so the state will put up your setting for public comment, and folks from the community, people that are using your services, family members and loved ones of people using your services can submit comments about your services and let people know if you're facilitating community integration and autonomy.
And then finally, the CMS and the state can submit consumer experience surveys. And so because the rule is supposed to be judged from the perspective of the consumer in the setting, they're actually going to be looking at how is the consumer experiencing the setting? And this is important as well because a lot of times when we've done provider visits, we found that while maybe policies have been in place that would allow people to go out to the community or allow people to make decisions, the consumer may not be experiencing the degree of community integration that the setting might think that they are. And so it's important to actually go to the consumers and see how they're experiencing the setting. Okay, so that's a lot of information, but that's all the information that would be gathered by the state and that CMS would be reviewing to see if they think that a setting could still bill as a home and community-based services setting. So what will happen is then, after all the information is gathered, CMS will review the information and will respond in writing. And if CMS has any further questions, they may in fact conduct a site visit. So after you've gone through all of this process and the setting is approved, then CMS is going to communicate the scope under which the setting is determined to be a home and community-based service. And they're going to indicate that any material changes to the setting may result in a reevaluation of the setting. And so again, remember here we're talking about settings. We're not talking about settings that need a few changes or some remediation to come into compliance with the rule. We're talking about settings that may isolate and that look institutional. And so CMS has decided that they need a higher level of scrutiny in order to determine if they can still operate as HCBS settings. And so even if you pass this heightened scrutiny, then CMS is going to put certain restrictions on you. And the restrictions are going to be that if there are any material changes to your program, then you're going to have to go through this process again. And so what CMS has said material changes are an increase in licensing capacity, the establishment of additional disability-oriented settings in close proximity, or changes in the ways in which community integration is realized. And so even after you passed heightened scrutiny, if you end up trying to increase your licensing capacity, if you build or set up other settings close by, or if you make programmatic changes that affect how community integration is realized, then you're going to have to go through this process again. Okay, and I'm going to turn the time over to Laura now to give you some examples of what these different settings look like.
Hello, everyone. So we realized that was a lot of information that we just threw at you, and a lot of dense information about regulations and examples, but hopefully it was helpful. So as many of you know, we've conducted we've had a lot of contact with providers, and some of the feedback that we've gotten is, this information is great, but practically speaking, what does this look like? What is a compliant setting? What is a non-compliant setting? And so we wanted to hopefully provide some examples during this webinar. So what does a compliant setting look like? Well, we think a compliant setting would offer multiple community activities each day. It would encourage individuals with disabilities to interact with people without disabilities. And just to be clear, when we talk about interacting with people without disabilities, we don't mean staff, but we mean non-disabled peers or community members. A compliant setting would assist an individual in their day program to pursue competitive integrated employment if that was something that an individual was interested in pursuing. It would maintain an open door policy for visitors from the community, but as we've touched on in this presentation, that policy would not be a substitute for folks going out into the community. A compliant setting would allow individuals to eat when and where they wanted, even if that was, at an off-site location. I certainly know going out to lunch is sometimes a very necessary break in my day. And clients would have individualized schedules so that they helped to create. So, essentially if one person at a setting wanted to, perhaps take a class at a fitness center and another individual wanted to, go to a park, the setting would be able to, accommodate both of those needs and desires, because the setting was so individualized. And we think that the good news about this is that this example is actually drawn from a real life setting that we visited, that we were very impressed with how it functioned, and and thought that it really ticked off all the requirements of the settings rule. And so we really thought that that was encouraging to see that that model is already at play and working in our community. Okay, so if that's a compliant setting, then what would a medium setting, or a setting that is going to require some remediation or some changes, but would not likely be subjected to heightened scrutiny? What would a setting like that look like? Well, based on the information from CMS and some of our preliminary data gathering, we think that it would look something like this. So a setting might offer pre-planned group activities in the community with little opportunity to interact with non-disabled peers. Individuals might set their own schedule most of the time, but there might be certain things that aren't individualized. So staff might plan doctor's appointments, haircuts, or other appointments for an individual without really including that individual in the planning process. The setting might restrict cell phone or internet use as kind of a blanket rule without really assessing and documenting the need for that restriction in a person-centered plan. And individuals would come and go as they wanted, with staff support as needed. But then there might be set meal times that individuals might adhere to. So in this example, you can see that there might be some things that a setting is doing really well and that are working to facilitate integration, and some things that are going to need some tweaking or some changes to become compliant under the settings rule. Okay. Oh, too far. I'm sorry. Okay, so what would a non-compliant setting look like? And obviously, this is the category that certainly, we don't want to see settings fall into, but hopefully some guidance for what it might look like if, in fact, a setting did. So a setting that was not non-compliant, or that would, again, be presumed to be not home and community-based, and therefore would not be able to receive waiver dollars, might look this way. So it might be located in an industrial area apart from the broader community. And obviously, what that's getting at is if a setting is geographically isolated, then it likely could be more difficult for that setting to facilitate integration, and that could be, a factor that would work against the setting, trying to show that they were not a setting that isolated individuals with disabilities. A non-compliant setting might also deliver multiple services on site, meaning, services are brought to the setting rather than people being afforded the opportunity to go out into the community to receive them. The setting might be located in close proximity to other settings controlled by the same provider. So, if a group home is very close to a day program or a workshop, that might be the type of setting that could prove to be problematic. And again, when you think about this in the context of this rule is designed to ensure that these dollars are not spent in institutional ways, you can see how this might be problematic, because if individuals with disabilities are kind of going back and forth, only interacting with the same group of people with disabilities, it can start to look fairly institutional in nature. Portions of the setting might be locked, prohibiting an individual's entrance and exit. There would be limited community access and difficulty scheduling appointments and visiting with family and friends. Here, I think it's important to note that there would be limited community access, not necessarily no community access. So it could be possible that a setting would provide for, some degree of community access, but still ultimately be determined to be a setting that isolates. Visitors might either be prohibited or discouraged from visiting the setting. There might be highly regimented schedules or a lack of choice about what services an individual receives. And the setting might be designed for individuals with a certain type of disability. So, for example, only for individuals with autism or Down syndrome or something like that. So CMS has termed that coming into compliance with the HCBS requirements transition. And we know for those of us steeped in the disability world, there are kind of a number of different types of transition, but transition for this process does mean the process of coming into compliance with the settings rule. And as we've discussed, states have until 2019 to do this. States will develop a transition plan that outlines how they intend to comply with the settings requirement in each of their waivers. The transition plan has to be made available for public comment, and I know many of you are probably aware of this and have looked at Utah's plan. So a question that we get fairly frequently is, so how can I be involved if I have thoughts or concerns, comments about this process? So we've tried to outline a few different ways that folks could become involved. The state has submitted the final plan to CMS, but must hold additional comment periods each time there are substantive changes or modifications to the plan. So in the past, when these substantive modifications have occurred, the state has opened up the plan for public comment, and when the state does that, certainly individuals or providers or families, any of them could submit comments as part of the plan, but you do have to wait for that comment period to open. Right now, the comment period is not open, but presumably moving forward, there will be additional comment periods, so that's a way to be involved, to review the plan and receive updates about the state's planning process. Some of the updates would certainly include when an open comment period occurred. You can join the Department of Health's mailing list that we've included on this slide. And you can also contact your state legislator and encourage them to support funding the $5 million for the final year of the DSPD Direct Care Staff Compensation Plan, as well as a $350,000 allocation for motor transportation payment rate. And the reason that we say you can do both of these things is that certainly in order to provide the degree of integration required by the rule, providers are going to have highly qualified and competent staff, as well as sufficient amounts of staff to help people get out and about as the rule requires. And certainly, paying direct care staff a competitive wage that will allow providers to keep staff is key to this. Obviously, transportation rates that allow for people to be transported from settings out into the community are also, in our mind, a key piece of this as well. And so we would hope that if this process is of interest to you, you would feel comfortable reaching out to your state legislator and telling them that you would support these two items, as well as just kind of making it known that this process, the HCB settings process, does need attention from the legislature. So that's another idea. And finally, you can attend the Disability Law Center's Strategies for Successful Integration on September 14th, 2017. So we would assume that if you're on this webinar, you likely know that the DLC has tried to, publicize this process and certainly work to educate consumers and providers and family members about it. And in our effort to be, helpful and to ensure that our state does come into compliance and that consumers of HCBS services receive the highest quality of services, we're planning this meeting for mid-September 2017. It will be a day-long conference, and we hope many of you will be able to attend. The idea for this conference would be to provide some more concrete examples of what integration looks like. Some of the things that we have thought about discussing at the conference are, what does integration look like for people with multiple types of disabilities? Integration throughout the life cycle, so looking at integration for perhaps children in school, as well as all the way up to individuals in assisted living facilities, etc. But we would hope that this could be a collaborative process, and that if there are topics that any of you might hope to see at that conference, you would let us know so that we can try to include them now as we're planning this. So for more information of this presentation, resources or fact sheets, we would encourage you to visit our website. We have a lot of information dedicated to HCBS there, as you can see, or if you have specific questions, or if you'd like a presentation perhaps tailored for your a particular community, you could ask for that at hcbs@disabilitylawcenter.org. I know that we have about 15 minutes left, so are there any questions? I'm not seeing any, but we'll wait for just a couple of minutes to make sure that, oh, okay, here's one. Okay, so this is a great question from Mary Kava. I'm sorry if I'm butchering pronunciation of your name, Mary. Her question is, will changes in Medicaid impact this act? What a good question for the time that we're all living in.
Yeah, I think that's, a great question. That's something that certainly has been talked about within the, the disability advocacy community. And I think, a lot depends on, what happens with Medicaid over the coming months. Certainly there's a lot of great material out there from national organizations like NHELP and the Kaiser Family Foundation. And I think a lot of it will have to do with what Congress chooses to do with Medicaid. So there is, a very real possibility that rather than changes in Medicaid affecting this rule specifically, that it will impact waivers rather than the rule. And impacting waivers would, of course, have the effect of impacting the rule. That being said, a state still has an obligation under Title II of the ADA to provide services in the most integrated setting possible. And I think the settings rule outlines, what CMS considers that to look like. So if for some reason waivers were impacted, the Title II of the ADA still stands. And I think, moving forward, that's something a state would still have an obligation to ensure that individuals have integrated services.
Yeah, and I would just add to what Marianne said that that again, if changes were made to Medicaid, that might impact waivers. And I think for all of the reasons Marianne outlined, that doesn't necessarily mean that the specifics of this rule would change, but I do think it's important to be mindful of the fact that waivers are part of Medicaid, and that as discussions are had about potential changes to meet that may be made to Medicaid, that it's important for people within the disability community to be aware that could have an impact on waiver services. Okay, the next question. Oh. What is the name of this PowerPoint or your website? Oh, on your website.
Yeah. So we will just have we'll post a link on our website to the disabilitylawcenter.org/HCBS, and Not exactly sure what that link will say at this moment, but we'll make it clear that it's our February 22nd webinar, and so that you can access that anytime you want. So we are recording this, and we'll post a version of that online in the next couple of days. Yeah, and I'm being informed we will send you all out. This is a great idea. We will send you an email with that link. So keep an eye out for your inboxes. In your inboxes, that a link to this PowerPoint and the presentation will be coming in the next couple days.
Okay, and Lisa said, are the slides available for review? So I think we just touched on that with the link that we'll be sending out. Okay. Are the rules regarding staff training, etc.?
Yeah, so I mean, I think the rules don't necessarily specifically state how staff should be trained. That being said, I think that obviously the rules will impact staff training because, again, this goes back to some of the rule requirements in terms of, you know, supporting people to access the community, supporting people to make choices, and that will require providers to train, you know, within staff training to help staff, you know, help individuals make choices rather than, you know, just do things for them. And so I think that really depends on your setting and how you currently train staff, and, you know, how, you know, also informing staff about the rule requirements in terms of, you know, integration and what that should look like. So I know that, you know, through DSPD for licensed providers, and the new licensing, they requires providers to say that they've read and understand, you know, the settings requirements. And I think this will necessarily apply to their staff as well. So I think this will impact staff training.
Do you know how long the waiting list is for DSPD services?
So I think right now it's around 25 or 2,600 individuals for the community supports waiver. There are 7 different waivers, so that, you know, those waiting lists do vary, but the community supports waiver is the largest waiver, and it does have a fairly lengthy waiting list. And I think the average time spent on the waiting list is about 6.5 years.
Okay, so this question says, my son has a disability that requires constant care. He is in a day program where he always needs one-on-one staff. How would this impact his day program for being compliant with these guidelines? He also, for his safety, has to have a door locked. He is 16, highly energetic, and is like a toddler, so there are safety issues. I'm sorry, I'm having a hard time keeping that question up, but I think we get the gist of the question. So, you know, if your son is in a facility a setting that, you know, receives waiver dollars, then that setting will have to be compliant with the guidelines and the rules as we've outlined them. I mean, I think our hope would be, and I think the intent of the rule would be that your son would still be able to have one-on-one staff, because that's likely what he would need in order to get out and about into the community. I think our hope would be that if other individuals in his same program, you know, needed the same degree of support in order to access the community, that they would have, the staff necessary to do that as well. With respect to the safety concerns, like the locked door, certainly there can be restrictions that are based on an assessed need. So if there is a documented reason that a particular individual needs, a restriction, then that can still happen, and it can be written into the person-centered plan. It's just important that before kind of jumping to that restriction, the provider look at what else is possible, and potentially try out other things before going to that restriction, and then also ensure that restriction is only applied on a case-by-case basis to the individual that it applies to, and not to potentially everyone in the setting.
Yeah, and I would also just note that in terms of making sure it's documented in the person-centered plan, that restriction would also then need to be reviewed every year to make sure that it's still necessary and it's still needed. So, it's perfectly appropriate to have restrictions that are needed for health and safety issues, but it just needs to be something that's documented and reviewed on an ongoing basis.
Sure. So do you anticipate more providers with these changes, or providers dropping out because of compliance issues and concerned about rural providers? So I think the answer to that is, as we've outlined, if a provider does fall into that last category of, they are a setting, and it's really the setting, not the provider, but I know we're using that a little bit interchangeably, because a provider could have some settings that look compliant and potentially some settings that aren't. But if a setting were to fall into, heightened scrutiny, and therefore it was presumed that it was not home and community based, and then if they weren't, that setting wasn't able to demonstrate that it actually was compliant, then yes, that's a setting that would not be able to serve waiver clients. And so certainly it's possible, if not probable, that certain settings will fall into that category. And that's why we're trying to do all of this outreach and education now, while we still have 2 years before all settings need to be compliant. But certainly that is, a concern of ours, that we as a state and as a service system be, thoughtful and be proactive to ensure that, as few individuals as possible would be affected, because nobody wants to see, people who are receiving services have to go, kind of scrambling or looking elsewhere. As we outlined, there's actually a piece of the transition plan that is supposed to talk about how individuals who might be affected by this would be, assisted to find a new setting that would be compliant. But certainly it could be a concern.
Yeah, I mean, and then also, the purpose of the rule is to make the home and community-based service system better. So having, multiple providers disenrolled from the waiver would not do that. So I think our goal, and, the state has been working towards this, is to ensure that everybody can come into compliance with the rules so that we can maintain, the number of providers that we currently have. With regard to concerns about rural providers, what I just want to go back to is in terms of community access and integration. Just as a reminder, that's supposed to, mirror your relevant community. So in rural areas, they're just, there necessarily will be, less public transportation. There may even be less public events. So if somebody in a rural location is getting less access than they would in an urban area, that still can be okay, so long as it just looks like how everybody else in that community accesses the community, community events and whatnot. So.
Are there resources to train staff on the HCBS Settings Rule? There are not additional dollars that I'm aware of. I don't think we've been notified of anything like that. Certainly that's why we're trying to provide information like this, webinars like this. We have our webpage, also the conference that we mentioned in September to try to educate the public. We're also open to conducting other presentations for perhaps providers or family groups. We don't mean to only highlight, our own services, but at this point, I'm not aware of kind of anything else that's out there to train people in the state. I know you mentioned contacting our legislators in order to get the budget needed to make the changes. Are there other options and resources to look for in this regard?
I think, right now, those two requests, we did a survey of providers about a year ago and found that the two biggest barriers to community access were lack of funding for transportation and direct care staff. And so certainly the direct care staff increases have, the salary increases have helped that, and that's why we would really encourage people to contact their legislator and ask them to, allocate that final year to raise the salary even more, as well as, support the transportation, because that's such a pivotal piece. But with regard to other options and resources, I think this is something that, really giving feedback to both your legislator and, the Department of Health, and because the Department of Health is actually in charge of the transition plan, we've been encouraging them. It would be great for providers and families and consumers to contact them as well and encourage them to look at things such as reimbursement rates, look at, how different service codes are funded to see if they, are encouraging integration or if there's other areas that need support. I think that's an area that's a little bit of a knowledge gap right now in our state.
You mentioned that a compliance setting would be able to individualize the supports provide to clients of one person. Sorry, yeah. For some reason, when we pull these up, they disappear. So bear with us. You mentioned that a compliance setting would be to individualize supports for one client. So if one person wants to go to a location in the community, another client wants to go to another location, that setting would accommodate this. Are you saying that the support would provide a one-on-one service? And I know there's probably more to that question. Oh, service or as a small group. Okay. So what we're saying is that what the rule requires is that if one person wants to go, out, that the setting needs to find a way to make that work. And so I don't think there's, a blanket assertion that everyone needs a one-on-one staff, nor is that what we're saying, but that that integration really needs to be individualized and driven by the person and not driven by, like pre-planned schedule outings for small groups of folks. And we realize that certain providers might struggle with that. And that might be a very real issue to work through about, how is a provider going to accomplish this? But like we said, at the outset, we did see a provider in a setting that was making this work, and I don't think that particular provider did have one-on-one staff for everyone. But the way their service model worked, it did, facilitate that type of choice for the people in the program. Can we have access to examples of other sites in Utah that have overcome obstacles, such as in the community integration aspect? We are working with a site that is planning remediation options, and they would like to see how others have done it to get ideas.
Yeah, right now we are, and I realize this may be a little too far out, so if it is, you're welcome to contact us via the email address that we included, and we can chat a little bit offline. But our hope would be that the September conference would address some of these things. So our thoughts for that right now are to be able to have providers who have gone through kind of, a transformation in their service model come and talk about how they did it, have family and consumers talk about what that experience was like. So our hope is really to provide some more practical examples in the September access of how some of these things can be realized.
I think that's just a clarification.
Okay.
We already answered that one.
So this question is, this seems to be in opposition to employment first. How can we make sure both are in compliance?
Yeah, so I think, the settings rule and employment first, there's some areas where they differ slightly, but I do see these as kind of being in harmony with one another, because they're both focused on, expanding access to integrated opportunities. And, the rule even specifically states that a setting should support full community access, including opportunities for integrated and competitive employment. I know that the Division of Services for People with Disabilities has their Employment First work group, and they certainly have, I think, begun talking about how it overlaps with the settings rule, and they're working to address that. But I think overall they're working towards trying to ensure that that individuals have integrated opportunities, and that the service system supports them to do that.
I am a DSPD external support coordinator. Several of my clients struggle to access the community due to paratransit not being able to go to their home. Any suggestions? The short answer is no, which is, not helpful, we know. Certainly paratransit is an issue, and it's an issue that we hear about from a lot of folks. I think what I would say, and going back to the legislator, is, to the extent that providers are involved in transporting people, and I realize this isn't going to be applicable to everyone in the same way, but to the extent that providers are, it's important that reimbursement rates for transportation make sense and facilitate, the ability of people to get out of their homes and into the community. And so, again, I think this is a really important issue because, as you rightly point out, if somebody can't, doesn't have a way to get out of their home or their, apartment, then, obviously this rule isn't going to be very meaningful. And so, again, as a service system,